Thanks a lot, Chair. Much appreciated. And I would like the members of the committee properly to understand the context within which I'm raising this point, because we are not as well vehemently opposed to the proposals made by the MK party. Firstly, we were making an intervention to say some of the issues that they have raised are already covered. But there is one particular issue, but of course, it's not a matter that we're prepared to go to the war to deal with. But there is one issue that, Chair, we believe that if we don't address it properly in this committee, it's going to open us into a direction that does not belong to the scope of our work. And we would like the matter to be properly discussed in this committee so that we can persuade one another. I said earlier on, Chair, in Parliament, we all belong to various portfolio committees. But the portfolio committee on the Joint Standing Committee on Intelligence, members of that committee go through a particular exercise which is defined by law before they qualify to be members of that committee. It may very well be that you might be a member of Parliament but have a difficulty to get the clearance that is required for you to be a member of a Joint Standing Committee on Intelligence because of the exercise that they've got to go through, given the nature of the work that they do. I'm making this background, Chair, to lay the foundation on the point that I was raising. When the MK party says the committee should adopt a protocol on classified information, I want to stop there. The committee shall adopt a protocol on classified information. What do we mean by that? How do we interact with the classified information when we ourselves are not members of the Joint Standing Committee on Intelligence and therefore have not gone through a process that is required by law before you can interact with the classified information? So if the committee members are saying, we agree, let's proceed, it's just the proposal here is that we must adopt a protocol. What do we mean by the protocol? Let me conclude by saying, Chair, I was expecting as well that the legal team will intervene on this issue. Well, in my own view, it's very strange that the legal team doesn't see anything wrong with the fact that we are about to agree on adopting a protocol on how to deal with classified information. Never mind sensitive information, because what is sensitive to me may not be sensitive to Kusela, may be sensitive to Nomvalo. That we can handle is understood. But classified information is not our own imagination. It has to do with what the law defines as a classified information. And I'm arguing, Chair, that as an ad hoc committee, in terms of the law, we are not empowered to engage with classified information. And I'm saying I'm surprised that the legal team, when they were commenting, when you pose a question to them as to whether do they see anything problematic with their submission in its current form and formulation, they said nothing. Now, if they insist that there's nothing illegal, can we also have them making an input? What do they understand about this committee having to adopt protocols on classified information? What is meant by that? And what is required in terms of the law of our country and Parliament before you can have access and deal with matters that are classified by the state? Thanks, Chair.
Yeah, thank you very much, Chairperson. Chairperson, if I may come in. One, this, Chairperson, comes from an apprehension of the allegations and the nature of the allegations which were tabled by General Nhlanhla Mkhwanazi, Chair. And amongst the allegations that he raised, or the concerns that he raised, is that there is an interference in the crime intelligence unit in South Africa. And our understanding, Chairperson, is that the crime intelligence unit at its heart deals with classified information. And therefore, at some point, this committee will have to deal with classified information in one way or the other, and whether we like it or not. Unless, Chairperson was saying, we are to a certain extent going to abdicate some of our responsibilities, because the terms of reference which were adopted in Parliament when the motion was tabled said that we must investigate allegations raised by General Nhlanhla Mkhwanazi. They did not say that except on issues of crime intelligence. So it means if you are saying here we're not going to deal with classified information, you are saying we're not going to investigate some of the allegations which were raised by General Nhlanhla Mkhwanazi. That's what we are saying. And what we're hoping to hear, Chairperson, from the legal team, we're hoping to hear them giving further clarification on different types of classification. That what kind of classification do we have? Because there are different levels, top secrets, sensitive, and so on. And to that kind of to those different categories of classification, to which classification can Parliament not have access, and to which it can have access? And for us to have access to that kind of classified information, then what process do we need to undergo, and what implications will arise from that process? That is what we're hoping to hear. But Chairperson, we are firm on the view that this clause needs to be added. This addition needs to be considered here as part of this document, because we believe that it's inevitable that we will deal with classified information as this committee, considering allegations and the nature of allegations that were raised by General Nhlanhla Mkhwanazi. Thank you very much.
Thank you, Chair. I thought that we have passed that until I've mentioned the issue of Phala, then things started. And now I agree with Honorable Member Malema when he said we need to sit on this meeting. I think Adam said so as well, that after that, perhaps some legal advice from lawyers or from wherever it comes from prompted Honorable Nduli to come back. The matter was done, Chair. The matter of our input was done. Now, because I invoke the issue of the minister, Senzo Mchunu, classified Phala issue, then it started to come back. If we sit physically, we won't have this, Chair. That you will have a matter discussed, at a later stage, it comes back. When it comes back now, even the legal advice has changed. He has changed. It's been pushed to change what he told us earlier. The issue of protocols and the issue of General Mkhwanazi, when we are sitting at when we had a joint sitting, is very, very clear. Let's not beat about the bush. We are not only talking about law here. South Africa needs to see justice in this country. We cannot be told, like I said in the meeting, that when Solomon Mahlangu was hanged, we were told about the law of this country. We need to go further as a committee. South African people and the population in this country wants to see justice. I don't hear the word justice here. I'm only hearing about law this, law that. We need to be frank about this thing. This commission should not be like any other commission we ever had before in this country. Where were optics, where people are defending each other, where the people are closing ranks. I'm not saying we must break the law, but I'm saying to you, justice, Chair, has to be seen to be done in this matter. I cited that deliberately to say this so-called classifier, if one person decides to classify a matter, we cannot be told that. In fact, I think it was a travesty of justice not to have some members of the joint intelligence, in fact, the joint intelligence with the justice and the police portfolio committee together in this Ad Hoc Committee. I think we missed an opportunity in that. But my last parting choice, Chair, is that we should not, please, we should not defend illegal things in this country and hiding it behind the laws which we know that our constitution is not perfect. You know, all this PR thing that we got the best constitution, that will be a debate for another day. But I'm still insisting that we should not be told in this Ad Hoc Committee that we cannot discuss this matter. This matter is a classified. We know what is classified. I was talking about what General Mkhwanazi told us. Nothing else. I'm not deviating from that. I'm saying we are dealing with the matter here of the South African Police Service and justice. And if we want to see justice, justice must be seen to be done and should not be optics. We should not just come here and defend issues and say those matters are classified matters. If we have to, then we will have to know what is a classified matter, because those matters are going to come anyway. Thank you, Chair.
Honorable Sangoni.
Thank you very much, Chairperson, for the opportunity. Chair, I think that as we go through these terms of reference, obviously ours is to discuss and hopefully try and find one another on the issues that are raised. So I think it's a bit unfortunate that as we seek to engage with members of the committee, there are views held that we should not have an opportunity to engage them thoroughly. Chairperson, my input has changed, I think, given the disclosure by Mr. Tetyana that there is a protocol on classified and sensitive information. But I want to propose that maybe what we want to do on that, what I think is a contentious a section that's proposed, like the MKP in the above, in the statements above, where it says the committee shall, where applicable, act in accordance, and then it mentions a particular act there. We should, in this section, also include that the committee shall, where applicable, act in accordance with the minimum information security standards. I think it's called MISS. Because to do that, it would then cover a lot of issues in terms of who is constitutionally empowered or legally empowered to deal with classified information. I think all of us want the same thing, which is ultimately to discover and understand the truth on these matters. But in doing so, we can't then be breaking the law. And I support your suggestion, Honorable Chairperson, that perhaps then we also get provided with that existing protocol on classified information, which will give us guidance in terms of what we can deal with or not. I hold the particular view that if you are not cleared to deal with classified information, regardless of what we may seek to achieve, you will not be able to deal with classified information in terms of the law. But the existing protocol of Parliament will guide us in that regard. So that is my submission of that edition of that we must act in accordance with national legislation. Thank you, Honorable Chairperson.
I'm just going to read perhaps one or two paragraphs of this document. I don't want to waste your time and the members' time. So it says a process of handling classified documents was developed over time, in terms of which these documents are placed in the custody of Parliament with access to them controlled. The documents are placed in a safe set aside for this purpose, equipped with two different locks. The Speaker or her nominee and the Secretary to Parliament or his nominee ensure the safekeeping of the safe keys and its contents. My nominee, this is the Speaker now, in this instance is the Secretary to the National Assembly, and the Secretary to Parliament will announce his nominee in due course. In order to gain access to the documents, it will be necessary for both key bearers to unlock the safe, take the documents to a controlled venue, and there, in a formal way, make them available to only full members of the committee. Members will require your permission to gain access, and on this basis, block times may be set aside during which the relevant members will have access to the documents. On entering the venue, members will have to identify themselves, sign a register, and record their time of entering and leaving the venue. Under no circumstances will these members disclose the contents of these documents, as that would be a breach of parliamentary privilege and contempt of Parliament. In terms of National Assembly Rule 2, this process has developed into a practice which forms part of sources of authority of the Assembly and must be followed in this case and other similar instances. Thank you very much, Chairperson.
So what you are saying is that this confirms that the protocol is there already.
Yes, Chairperson.
And then as the committee, when we do our work, we must subject ourselves to that protocol.
That's correct, Chairperson.
Okay. Then let me go
Yeah.
back to the list. I think the matter is now very clear. Let me go
Yes.
back to the which is Honorable Ntuli and Honorable Matthys.
No, thanks, Chair. Let me not be long because in the light of what has been indicated here, I want to propose that we, rather than adopting the paragraph in its current formulation, we allow an opportunity, maybe at the end of this meeting, for the legal service to insert a paragraph that clarifies what he was reading. That's what I'm proposing. I'm still very firm on my understanding that of how classified information are handled in South Africa. But I have no problem with the protocol being inserted. But I suggest that let it be inserted so that when we end the meeting, he must present the protocol and the conditions under which the protocol is going to be applied so that we can be off the same page about it. Thanks.
Honorable Matthys.
Thank you, Chair. I think we largely covered after the reading from the legal team. What I would like, or what we would like to raise, is that there is a process for documents that are classified to be declassified legally. And I would like to think that we would like this committee to be able to unravel whatever criminality. I mean, we do know that documents pretty much get classified also to cover up criminality. So there is legislation available to us if needs be, and if anybody comes to the committee and says, I have classified information that is criminal, its contents is criminal, and we should be able to help speed up that process of getting those documents declassified, if it is going to assist in us meeting our objective of this ad hoc committee. Also, we do have members of the Joint Standing Committee that are part of this, but I'd written down this point, but I think I'm largely covered. We also don't want to have a situation, Chair, that every time something comes up here, remember we're trying to fix a very hectic problem here in this country about the criminality, and that our entire law enforcement is in a horrific state where we're going to end up with mob justice here in this country. So if we want to do something serious here as a committee, as we are mandated to do when we took our oath of office, we need to make sure that we also don't allow documents to be automatically disclassified. So that whole classifying process is abused. So information cannot come here to the committee for us to be able to clean up the criminality that is happening in this country. So one of the things is, us have been able to assist if information is classified and get it declassified. And on the second point is that also that we must also get information on when a particular document was classified. And this would speak to the issue of if documents are being classified now, given that we have set up this ad hoc committee to avoid us investigating further. And that's our input. Thank you, Chair.
Thank you so much, Honorable Matthys. The list of speakers is exhausted. I'm now giving to
No,
the
my hand is up, Chair.
Chair, my hand has always been up.
My hand is up.
No, there is no way I won't give you a chance. I mean, you are the ones who moved the proposal. So when everybody has spoken, you have the right to reply.
Okay.
Nhlanhla also
Noted,
Nhlanhla's
Chairperson.
hand is also up.
No, it's fine. Let's take the hand of Honorable Nhlanhla first, so that the MKP can be able to reply.
Thank you very much, Chair. Chair, I think we all share the same concern the MKP has raised. in that the nature of allegations that were leveled by General Mkhwanazi actually would at some point require us to deal with some sensitive information, classified and all those things, because the nature of the allegations include crime intelligence, as they say, IDEC and all that. Now, I'm also comfortable with the explanation that was done by the legal team, Chair, that we have got an established protocol that which directs us on how to deal with matters relating to classified information and all that. And I want to come and second the submission by the Chief Whip that there must be an addition of a paragraph, but the addition of the paragraph must speak on us when the time arrives for us to deal with classified information. We must use the established protocol of Parliament. We are just an ad hoc committee of Parliament when there are established protocols on how to deal with a certain information. I think we must use that already established protocol, and I think the addition the Chief Whip is talking about should actually speak about how we align ourselves with the established protocol. Thank you very much, Chair.
Honorable Nombalo.
Yeah, thank you very much, Chairperson. Chairperson, I do not understand where the bone of contention is here, because this is our understanding, firstly, as the MK party. Our understanding is that this heading, which deals with the legal framework, the heading that we are currently under, is a heading that deals with the law or any piece of legislation that governs the framework or the scope of the ad hoc committee. I think that is a standard heading that should be there in the terms of reference, but in it, there should be no suggestive of any law that should be developed by this committee, but rather it deals with the law that is going to guide the operation of this committee. That is our understanding. Now, by saying, Chairperson, in this edition that we have made, by saying that the committee must adopt a protocol, we do not say that we must develop our own protocol. We are saying we must adopt the protocol that is already in existence. In this sense, Chairperson, there is no way that regarding these allegations made by General Mkhwanazi, there is no sensitive or classified information that will be submitted to this committee, whether through an invitation or voluntarily by any member of the public. Now, when that information is at hand, what is going to be expected of us as a committee? One, because we're going to have a legal advisor as the committee, a person who's going to advise this committee on a regular basis. That person will tender a legal advice and say, this information is classified. And if it is classified and the committee makes a determination that it is relevant to assist an inquiry, then we ask a question, which protocol can we follow if we want to use this information as part of an information that is going to assist our inquiry? And then it is then that this protocol, which is already in existence, will be applied to say, this is a process in terms of the protocol that is in existence that will be applied. So, Chair, my observation here is that Honorable Ntuli does not understand where we're coming from. I think he thinks we're saying we must develop our own protocol. We're not saying that. We're saying there is no way, it's inevitable regarding the nature of allegations and regarding the institutions that we are going to deal with as a committee, that we cannot receive an information that is sensitive. Now, when that information is before us, what are we going to do? We will be guided by the existing and the established protocol. and will be guided obviously by the legal advices that we'll be getting from a person who will be legally advising the committee. So here we're being understood from a wrong perspective. And that is why we've wasted so much time debating something that we actually do not disagree on here, Chairperson. We are saying here, we are putting a clause which ordinarily should have been put by the legal team when they were establishing this document. They have omitted putting it because under the legal framework, you put all the legal pieces or all the legal information or all the legal sources, rather the constitution and legislations that you think that will be relevant to the operations of the committee, the constitution, the pieces of legislations. So that's where we're coming from. There's no disagreement here, Chair. So I think we must chill a little bit. Thank you very much.
Thank you so much. Look,
Chair, my last parting shot as well from MKP. One sentence, if you allow me.
will you say 1 second?
Yes.
No. Let me give you 1 minute, because in a second you can't say anything.
Yes. No. What I wanted to say, Chair, I think Honorable Nomvalo has summed it up, you know, and I guess that we were in this point for almost 12 or 15 minutes now. My last parting shot from MKP is that I think Honorable Matthias as well said it will declassify where the matter will follow the protocols like they are there. But when we were putting this, we were very clear and ambiguous, you know, in terms of what we were doing. We know exactly what we were talking about. And this was adopted earlier. It just changed some way. We were past that. Unfortunately, you allowed members to bring it back because after what I said. But what I'm saying to you, Chair, we've seen in the past that, you know, this issue of the law, this law, that. I'm closing by saying, you know that we still have a sealed. We don't want anything to be sealed here or classified and being told, no, this one is untouchable. Then let's not even start this core committee. Then let's close shop. Because we will be told by people, you know, we've got IDEC, which we still have to come, like NPA and others. And yeah, Papa, thank you, Chair.
Your 1 minute. Your 1 minute has expired.
Thank you, Chair.